Hi, I'm Joel Beck from the Beck Law Firm LLC in Lawrenceville, Georgia. One of the questions we get from estate planning clients from time to time when we sit down with them to discuss their will is this: do I need to list all of my assets in my will along with who should inherit that asset? Well, the answer is generally no. Not every asset needs to be specifically listed in the will. Some assets certainly should be listed in the will, identifying what the asset is and who should receive it. For example, if you want to give a piece of real estate, whether your primary home, vacant land, a vacation home, or something like that, to a particular person, we generally want to list that specifically in the will. If you have rights to certain tangible or intangible property that can be passed down, then we need to list that as well. Here I'm thinking of rights to purchase sporting tickets, PSLs, personal seat licenses, and the like. In one case, we had a client who, since quite some time ago in the 60s or 70s, acquired the rights to a Masters golf tournament badge for each year, and that could be passed down to his spouse. So we needed to list that into the will. Also, if there's some particular piece of personal property that you want to make sure goes to someone specific, whether it's a car, a coin collection, jewelry, a ring, a piece of art, antique furniture, money in a particular account, or what have you, then we want to identify that asset and who should specifically receive that. Now, some of these items may have either great financial value or sentimental value within the family, but if for some reason you want that particular piece of property to certainly go to somebody, then we want to list that specifically. Listing those assets in your will can help reduce fighting or arguing following your death, as your will gives clear and specific instructions about what is to be distributed to whom. Now, having said that, I'm pretty sure that I've never completed a will for anyone that identified every single piece of property that that client owned, identifying it and describing who was to receive each piece. That's just not practical. In today's society, of course, we add and subtract from our estate very often on a daily or weekly basis, perhaps buying and selling or giving away things with great frequency. And to address this, then you can deal with that in a few different ways. One way is to simply identify who is to receive your residuary estate, and that is everything else that you owned that has not earlier been specifically identified and distributed to somebody. This residuary estate could be left to your spouse if your spouse survives you, then to your children if they survive you in some type of equal shares or unequal shares as you see fit. Then when the executor distributes the residuary property, the executor will make the decisions either with or without family input on who gets what based on how you've left the property. Another way is to have your will mention a memoranda of personal property that may be found with your will and other important papers. With this approach, you fill out a memo, essentially a 3-ring or spiral notebook, listing out certain pieces of property and who to receive it. For example, your notebook may say that the kitchen table and chairs go to Joyce, the Matchbox car collection goes to the nieces and nephews in equal shares, your books go to Fred, and what have you. Then, if you still have these items at the time of your death, the executor will typically distribute these assets in accordance with that memoranda, assuming that the memoranda is found with the will and that the distribution plan is not terribly difficult. Keep in mind, however, that this memoranda approach is not legally binding on the executor because it's not technically part of the will, but this type of arrangement often works out very well. So the bottom line is this: if there is a piece of personal property that absolutely must go to another person, then do one of two things. Either give it to that person before you die, or make a disposition of the property specifically in your will. If you've got questions about estate planning, wills, trust, healthcare directives, powers of attorney, and the like, and how to make sure that you and your family are protected, well, reach out to us here at the Beck Law Firm. You can request free information from us about estate planning in Georgia on our website, or simply pick up the phone and give us a call. We'd be honored to assist you. Thanks.